All right. Good afternoon. It is the 22nd of September, 2020. I'm Luke Clipping, the chairman of the House Judiciary Committee, and we are here for a briefing today related to the reopening of the court system and to the access to justice work group that the Attorney General has established. We're going to try and keep it as close to an hour and a half as we can, because I know that everybody has a lot of other things that they need to do as well. But to that end, I'm not going to spend a long time with an introduction. I want to leave more time for questions. So we will start with Chief Judge Barbera, who has joined us today and is not muted. If you do have a question, please, you can indicate it in the chat. I'll be keeping an eye on the chat, and you can either raise your hand in the chat function, or you can, or just say you want to ask a question, and I'll take care of it from there. But with that, Chief Judge.
Good afternoon, Chairman Clippinger, Vice Chair Atterbury, and members of the committee. I hope that you are all continuing to be safe and well. For those who don't know me, I am Mary Ellen Barbera, Chief Judge of the Court of Appeals of Maryland. And with me this afternoon are three of our administrative judges, Judge Laura Ripken, who is here in her capacity as Chair of the Conference of Circuit Judges and as Circuit Administrative Judge of the Fifth Circuit and County Administrative Judge of the Circuit Court for Anne Arundel County. Also here is Judge Sheila Adams, Circuit Administrative Judge of the Seventh Judicial Circuit and County Administrative Judge of the Circuit Court for Prince George's County. We also have Judge Brian Shockley, County Administrative Judge of the Circuit Court for Worcester County. Also here are Pam Harris, our State Court Administrator, and Kelly O'Connor is here as well, both to answer your questions if you have them for either of them. Thank you, Mr. Chair, for inviting the judicial branch to discuss the work that has been done by the circuit courts to resume jury trials with safeguards in place to prevent COVID-19 transmission. Although the state of Maryland locked down in March, we did not shut down. The judicial branch responded with emergency measures to provide access to justice for those in urgent need. Since those earlier days of the pandemic, we have moved deliberately and carefully through a phased resumption of operations during the COVID-19 pandemic. We have monitored positivity rates and incorporated the health protocols urged by the Centers for Disease Control and Prevention. On October 5th, just under 2 weeks from today, the circuit courts will resume jury trials. Let me be clear, though, members of the committee, that so long as the COVID-19 emergency continues, health protocols will remain in place as they should until the CDC and the Maryland Department of Health tell us it is safe to do otherwise. As you are likely aware, jury trials require the assembly of large groups of citizens in order to allow the selection of an impartial jury. Doing this responsibly while safeguarding due process is a complex challenge, as you can imagine, one that the leaders of our circuit courts have worked hard to meet. The courthouses of our 24 circuit courts are all different. Each circuit court has had to develop a plan that would work in a particular setting. The administrative judges who are here today will tell you of the work done to ready the circuit courts across Maryland for jury trials. I have noted that before the resumption of operations, I've noted that the resumption of operations does not mean business as usual for the Maryland judiciary. Our practices necessarily, as you can imagine, changed. We will, though, continue to safeguard as much as we reasonably can the health of the public, judiciary personnel, and our justice partners. The ability of the Maryland judiciary to rebuild operations during the COVID-19 emergency would not have been possible without the dedication of leaders of our courts and their equally committed personnel. I am grateful to all of them for their steadfast service and unwavering commitment to the mandate of the judiciary during these difficult and unprecedented times. The judicial branch of Maryland, I can assure you, will continue to move forward unless and until the guidance of health experts cautions otherwise. The people of Maryland can depend upon access to justice. We still, though, have a long road in front of us, but Mr. Chair, Madam Vice Chair, and members of the committee, we will get through this, all of us, you and we, all of us, because we must. We must do it for the people of Maryland. Thank you for the opportunity to present to this committee. I will ask Mr. Chair if we may take questions at the end of the three judges' presentations. Thank you. I will then call upon Judge Ripken to address the committee. Judge Ripken.
Thank you, Chief. Good afternoon, Chair Klippinger, Vice Chair Atterbury, and members of the committee. I, as the Chief indicated, am Laura Ripken, here today in my capacity as Chair of the Conference of Circuit Judges. As the Chief noted, I am also the Administrative Judge for the 5th Judicial Circuit, as well as you know, Mr. Chair, the Administrative Judge for Anne Arundel County Circuit Court. Let me begin my remarks by sharing with you a brief video that demonstrates the preparation of circuit courts across the state for the resumption of jury trials. This is an informative video that provides information for the public on COVID-19 safety precautions as jury trials resume. Should be coming up.
I think I was disabled to share my screen, Holly. Can you
I'll go ahead and share it then.
Still not letting me share. Not let me share my screen.
Trial by jury is a constitutional right. Serving on a jury is a civic duty and the cornerstone of the United States justice system. Whether you have been summoned recently for jury service or not, the Maryland Judiciary's goal is to protect all visitors to the courthouse during COVID-19. We realize that some people may feel nervous about serving jury duty or coming to the court for any reason, especially during the current COVID-19 public health crisis. The Maryland Judiciary wants you to know that we are taking all the proper precautions and following the Maryland Department of Health and Centers for Disease Control guidelines to prevent the spread of COVID-19. Please be assured that the judiciary is doing all it can to ensure court visitors and employees remain healthy by providing a clean and sanitized courthouse for all. Routine cleaning of frequently touched surfaces occurs regularly. You will also find hand sanitizer stations throughout the courthouses. Further, everyone entering the courthouse, including staff, are required to wear a face mask at all times. The jury assembly and deliberation rooms and courtrooms have all been modified to comply with COVID-19 health guidelines. All jury assembly and deliberation rooms are set up to adhere to social distancing requirements and provide that all jurors will be at least 6 feet apart at all times. Plexiglass shields have been installed throughout the jury rooms and courtrooms for your protection. Additional rooms will be utilized to prevent going over the maximum capacity that each room is assigned based on social distancing requirements. The judiciary has limited the amount of people who can ride at one time in court elevators. If you are summoned for jury duty or come to court for any reason, please note that you must follow these 4 requirements when arriving at the courthouse. Wear a mask or face covering at all times. answer a series of COVID-19 health screening questions, have your temperature taken with a no-contact thermometer, and maintain a social distance of at least 6 feet apart. In addition, if summoned, please continue to monitor instructions from your local circuit court jury office. You can also visit the Judiciary's Jury Service Frequently Asked Questions webpage for more details about serving jury duty. If you are coming to court for any reason, you can check for updates by calling your local clerk of court. The Maryland Judiciary is committed to protecting the health and safety of jurors, trial participants, judiciary employees, and the public. On behalf of the Judiciary, thank you in advance for your patience and cooperation during this extraordinary time.
With respect to the 24 circuit courts in the state of Maryland, daily operations of essential functions have continued and expanded consistent with the phases of the administrative orders issued by Chief Judge Barbera. As you have heard previously, this series of orders was issued regarding the phased expansion of judiciary operations in light of the COVID-19 pandemic. We have progressed from emergency operations in phase one through each phase and are now in phase 4. On October 5th, as the chief indicated, we will expand to phase 5, full functioning of the circuit courts. Full functioning, as you know, means we will hear all case types. However, it does not mean back to business as usual. The safety and health measures depicted in the video, consistent with current advice from the CDC, the Maryland Department of Health, and local health departments, all will continue as necessary measures for those coming to the courts, our justice partners, and judiciary staff. Since the beginning of March, circuit courts have been working towards and preparing for phase 5. Every county administrative judge in the state of Maryland has attended remote meetings up to 3 times per week since the onset of the emergency in March. As you know from previous briefings, the circuit courts have continued to handle a wide range of matters consistent with the phases. We have also communicated not only with the Maryland State Bar Association, but also with our local bar associations, participating in meetings and webinars to ensure that attorneys and the community are provided accurate information related to court functioning during this emergency. Circuit court administrative judges have worked tirelessly to provide information to the community, working hand in hand with the administrative office of the courts. We are getting accurate information to the public. We have updated our websites regularly, done media interviews, created outreach documents and videos such as the one you have just viewed. The Conference of Circuit Court Judges has created 2 work groups. The first work group was the reopening work group that issued a report containing recommendations related to effective functioning of the circuit courts during the emergency and a plan to get to full functionality. The second work group was the work group on the resumption of jury operations in the circuit courts. That work group was chaired by Administrative Judge Sheila Tillerson Adams. You have been provided a copy of the report of that group, authored and dated August 3rd of 2020. I am pleased to introduce to you Judge Adams, who wears many leadership hats in the judiciary and is here today as the chair of the work group to provide you with further information. Judge Adams.
Thank you. Good afternoon to Chairman Luke Clippinger, Vice Chairman Vanessa Atterbury, and distinguished members of the House Judiciary Committee. I'm Sheila Tillerson Adams, Chief Administrative Judge of the Circuit Court for Prince George's County in the 7th Judicial Circuit of Maryland. As a member of the Conference of Circuit Court Judges, I was asked by our conference chair, Judge Laura Ripken, to chair the conference work group on the resumption of jury operations in circuit courts. The work group was comprised of a cross-section of judges, clerks, jury commissioners, and court administrators from across the state to address the issues that all circuit courts might encounter, notwithstanding the size or location of the court, in resuming jury trials in this state during the COVID-19 pandemic. The work group met weekly from May 19th through July 21st via conference call to discuss the issues regarding resuming jury trials in Maryland circuit courts. Recognizing that every circuit court in this state is different, the work group attempted to address every conceivable aspect of a jury trial in order to provide jurisdictions with tools and ideas that they could use to effectively resume jury trials in their jurisdictions. As part of the fact-finding of the work group, we looked to sister states such as California, Texas, and Ohio that had started some form of trials for lessons learned. We also reviewed reports issued by the federal courts and trial advocates, just to name a few. Our final report focused on how to keep jurors safe because just like our life now, evidenced by the Zoom presentation today, jury service also will look different. The days of packing jurors in jury rooms across this state and sitting shoulder to shoulder in a jury box are over for now. Our recommendations prioritize keeping jurors safe and staff safe during this pandemic. All jurors will be screened before they come into the courthouse. Their service will be rescheduled if they are sick, have symptoms, or have been exposed to someone that has tested positive for the COVID-19 virus. Additionally, temperature checks and masks are required at all courthouses. Specific to jury rooms, all touch points such as water pitchers, magazines, reusable jury cards, etc., that could spread germs have been removed from jury rooms and courtrooms. The plan covers safety from the jurors' arrival to the court to their dismissal. So, with these tools, jury selection across this state will be a very different, but all processes will follow the same safety steps of mask, temperature checks, reduced touch points, and social distancing. Now, some courts will stagger their jury panels to bring fewer citizens to the courthouse at a time. Others will use technology to assist with the juror process, and still some will partner with other venues in the community, such as firehouses, theaters, school auditoriums, and even fairgrounds, to allow for greater social distancing in order to accommodate a jury panel. Now, I will share with you what a day in the life of a citizen called to jury service in Prince George's County for a criminal case and a civil case will look like in this COVID-19 environment. Now, in a criminal case, enough jurors will be summoned to try 2 criminal cases on Mondays, one panel at 7:30 a.m. and another at 11 a.m. The jury lounge with a COVID-19 capacity of 71 and our ceremonial courtroom with a COVID-19 capacity of 35 will be utilized as dual jury assembly rooms where jurors will be socially distant, sitting 6 feet or more apart until they are ready to be called into the courtroom. Now, in the courtroom, jurors will be socially distanced across 3 large courtrooms connected by technology. The judge and attorneys will be able to conduct voir dire, meaning see and say. Voir dire is the process under which judges question potential jurors to select an impartial jury panel for the trial, and is translated to speak the truth. So, voir dire will be conducted simultaneously through all 3 courtrooms, thereby keeping jurors socially distanced during the entire process. When the jury is selected, they will be seated in the jury box and one half of the gallery. A connecting courtroom will be used for the jury deliberation room to allow adequate space. Additionally, another connecting courtroom will be used for the public and the press to view the trial electronically. Now, if you're summoned for a civil case, the jurors will be summoned for a virtual voir dire to be conducted via Zoom. The voir dire will occur on Wednesdays in civil cases. Jurors will participate with their electronic devices from their homes, and those selected will be instructed to report to the courthouse on Thursday for trial. 2 courtrooms will be designated per civil case, one for the trial and one for the deliberation room, in order to adequately provide social distancing. All courtrooms have been outfitted with plexiglass, wipes, hand sanitizers, and remote communication devices to allow counsel and the court to communicate without the need to approach the bench. So at this time now, I'm going to turn the presentation over to Judge Brian D. Shockley, Administrative Judge for Worcester County, so that he can share with you what jury selection will look like during a pandemic in his jurisdiction. Thank you for the opportunity to share this information with you today. Judge Shockley.
Thank you, Judge Adams. Chair Klippinger, Vice Chair Atterbury, other members of the committee, good afternoon. My name is Brian Shockley, and as Judge Adams said, I am the administrative judge here in Worcester County. And it's a real pleasure to be here, and I appreciate the opportunity of addressing you on this very important issue of the resumption of jury trials in the age of COVID-19. Rest assured that this issue has been front and center for all of the courts, and a tremendous amount of thought and effort has gone into developing individualized plans to resume jury trials in a safe, secure, and efficient manner. Judge Adams and her work group did a tremendous job and developed an excellent report that serves as a template for the rest of the courts around the state as far as resuming these jury trials. That's been included as part of your package, and she discussed it at length, so I'll try not to repeat any of that which is already before you. But suffice it to say, we here in Worcester County have adopted all of the general guidelines set forth in the report related to health safety, such as screening, distancing, sanitizing, plexiglass barriers, cleaning, etc. The primary difference between what we're doing here in Worcester County and, for example, Prince George's County and other jurisdictions relates to jury assembly and the voir dire process. Our courthouse in Snow Hill is relatively small, consisting of only 3 courtrooms. Our jury assembly room in the basement of the courthouse seats 60 jurors shoulder to shoulder in the old days and would probably only accommodate about 15 jurors now. In short, the size and configuration of our courthouse presents challenges for jury assembly and voir dire. In exploring options, we began to look off-site. We were unsure of how our local schools were going to be operating, so that really wasn't an option. And quite frankly, there aren't that many other options here in Snow Hill. We were fortunate to reach an agreement with the Snow Hill Volunteer Fire Company for use of their 4,500 square foot social hall, which is one of the biggest structures here in town. It's located about a mile from the courthouse. Once we identified the site, we worked closely with the health department, our local health department, as well as our sheriff to make sure that we didn't have any outstanding security issues. The space will accommodate about 80 jurors, all spaced, and provides ample parking. Instead of reporting to the courthouse, as you normally would for jury duty, you'd simply be summoned and report to the firehouse directly, where you'll be screened and otherwise checked in. Once the jurors have assembled, we'll proceed with the voir dire and the jury selection in that same room. Those jurors those of the panel who are not selected would simply be excused and they would go on home from the firehouse. Those selected, once the jury is sworn, would return back to the courthouse for the jury trial to commence. Back at the courthouse, we'll conduct 1 jury per day. I believe that's our limitation. All the jury trials will be conducted in our largest courtroom. 6 of the jurors would be situated all spaced in our jury box. The jury box typically holds about 14 or 15. The remaining jurors would be spaced on the same side of the courtroom, We'll reconfigure trial tables so that the attorneys can make their presentation to the jurors in a practical way. The jury deliberation will take place in an unused courtroom. Plexiglass barriers have been installed in all of the courtrooms, and all health safety measures have been implemented as outlined by Judge Adams. Those were taken to heart here in Worcester County, and those have been implemented to protect the safety of the jurors, staff, and all other participants in these trials. That's our plan here in Worcester County, but as with every plan that we've tried to implement since March at the beginning of this, it's a work in progress and subject to tweaking and adjustment. But I believe this plan is best suited for our circumstances here in Worcester County, and I'm confident that we can resume jury trials in a safe, secure, and efficient manner. Thank you again for the opportunity to address you on this very important issue. Judge Ripken.
Thank you. Thank you, Judge Shockley. A few final words from me in my capacity as the administrative judge in Anne Arundel County Circuit Court. As you know, Mr. Chair, we are reimagining our courthouse in Anne Arundel County. Our library is becoming a socially distanced jury selection area. 2 courtrooms will become 1 with the use of technology to create another jury selection space. And the traditional jury assembly area will be yet a 3rd space used for this purpose. The community college, the Anne Arundel County Community College, has also offered yet additional space for potential jury selection in civil matters. 4 courtrooms have been reconfigured for jury purposes. Our county has built plexiglass structures to add to counsel tables and even hanging plexiglass in the jury boxes. Technology will be used in lieu of bench conferences, and juries will remain in the courtrooms for deliberations. All this while creating a functional law library in the attorney lounge of the Anne Arundel County Bar Association and reconfiguring the self-help center so that it too can serve those in need. Other jurisdictions across the state have been likewise resourceful in preparation of conducting jury trials in a safe and secure manner. Baltimore City has reimagined the spaces within the court as well as it has success in moving forward with plans for remote voir dire in civil cases. Montgomery County has also reimagined spaces within the courthouse. Harford County and Howard County are doing the same while pursuing several possible remote locations for additional jury selection purposes. Garrett County is making use of the high school gymnasium. Dorchester County has arranged use of the Governor's Hall, which is actually an old warehouse. And yes, Baltimore County is considering the Cow Palace at the fairgrounds. We have been working towards this time since March. On October 5th, the circuit courts of the state of Maryland will be ready. Having heard the information about these preparations and armed with the understanding of how extensive these preparations are in terms of safety for the community, you might ask, how can we help? Here's how. Please, as the leaders of the community, help us spread the word that it is as safe as it can be in the circuit courts in the state of Maryland. We are prepared. We are ready to resume jury trials. I would be remiss if I did not take a moment to acknowledge the tireless work of the staff in each circuit court, as well as that of our colleagues in the district courts across the state of Maryland and the appellate courts, including administrative staff, the staff of the clerk's offices, and the judges themselves, who are all on the front lines of the judicial branch. I thank you, Mr. Chair, and members of the committee. I thank you for this opportunity on behalf of the circuit courts of the state of Maryland.
All right. Thank you all very, very much for your comments and your insight as to what happens next with regard to jury trials and the reopening of the courts and where we stand in that process. I am looking to see if there are questions from the committee, and at the moment I don't see any, so I'm going to ask some questions myself. Can we go back? I have questions again about how voir dire would work. Traditionally, voir dire, you would have members of the jury who would be in a courtroom. They would then come up to the judge and both the state and defense counsel after having indicated that they perhaps had a prior connection either to that case or to another case, and not getting into the details of it, but they go up for what is meant to be a private conversation. Can someone again describe how that will happen virtually?
Judge Adams?
Yes, thank you. We've had 2 virtual mock voir dire. So it works. With Zoom, we break the juror, the attorney, and the judge into a breakout room, and they can have a private conversation and no one else can hear it. So with the virtual civil voir dire, you'd break them into a breakout room, and it works just fine.
Okay, so would that be, so that's what we would be doing in criminal and in civil cases?
No, that's in civil. In criminal cases, it would work in the scenario I described in Prince George's County. The citizen would come into the courtroom after you have the preliminary questions via the electronic devices in the 2 courtrooms. Then the jurors that answer affirmative that they have a response, then they're brought into the courtroom with just the attorneys and the judge, and they're questioned on all the questions they responded yes to, so they can get it all at one time. And then after they respond, they're released. So they still have that private one-on-one with that juror, the attorneys, and the judge. It takes a little longer, but we still have that.
I don't question that. It will, but I understand what you're saying.
And we actually had 3 mock trials in that, and it worked. It did take a little longer, but it worked.
Mr. Chair,
please, Judge Ripken.
If I could follow up, because it's happening different ways in different jurisdictions. One of the things that we will be making use of in Anne Arundel County, as I know a number of the other jurisdictions will be as well, are devices that eliminate the need to approach the bench. And so there is we have ordered a set of 4, and I'm happy to show you how they work. There's a device for each attorney, for the defendant, and this would be in a criminal scenario, as well as the judge. You put the devices on and you communicate through the already set speaker system, the microphones in the courtroom. Therefore, there's automatically a record made. You turn on the regular white noise and nobody else in the courtroom can hear, but everybody can remain seated where they are as opposed to approaching the bench. And I know that jurisdictions across the state ordered those because I shared that information with all the administrative judges, and my court administrator promptly got, I think, 24 questions about where do you order those from. So they're being installed at various jurisdictions where they will work in that regard. So those will be used as well during jury selection.
Let me go to a basic, maybe a first principle, a basic question. Remind me and the committee the age by which that seniors can opt out of jury service again. Is it?
I think it's 70, but I think
it's 70. Okay.
I wouldn't swear by it.
It's 70, I believe.
Yes.
Yeah, and one of the concerns that's been expressed by practitioners and another number of other people is the challenges that people will have in the jury pool who have pre-existing conditions or have conditions that put them at higher risk with exposure to COVID. Has the judiciary taken steps to address, you have a person who perhaps is under current treatment with chemotherapy. Would they be excused from jury service, or do you, I understand I know you're going to say it's a case-by-case basis, and that's fine. I'm answering my own question a little bit, but that is something that I get consistently from constituents is how do we do this if we have a pre-existing condition?
Well, first of all, Mr. Chair, you get a one-time free reset on if you receive a jury summons and you do that remotely. So that's would be the first step. But the second step is certainly it is a case-by-case basis, but I am 100% sure that in the scenario that you described, that individual would certainly be excused from jury service and it would be rescheduled to a time after the emergency when it was safe, when it would be safe for that person to return. But all jurisdictions have jury judges who address these issues on a regular basis in pandemic times and non-pandemic times, and are certainly prepared to be flexible in that regard.
All right, I'm going to go. Delegate Moon has a question. I have a few more questions, but I'll kick it around here a little. Delegate Moon.
Okay, thank you, Mr. Chair, and thank you, judges. And you might appreciate that. Hopefully mine aren't seen as too off topic, but we don't get that much time to talk to one another, especially these days. So thanks for joining us. And hopefully these will be quick and not too impolite questions, but I'd like to get right to the point. The first is, as regards safety, I was asked by some workers to just raise, workers in the courthouses to just raise a concern about what the enforcement of any safety protocols is going to look like. Just anecdotally, I've heard there may be some concern about judges themselves perhaps not being consistent fans of some of the masks and other protocols, and it would sort of put folks in an awkward position, I think, who are not the judge, obviously, in that scenario. So that's a basic question. The second question is a lot more specific, and it's a bit of a right turn here, but I just would like to take the opportunity to ask if you might revisit the decision as we're looking at the pandemic and reopenings of the courts on evictions. We're sort of early into this September 22nd, but I believe you unrolled this process with the evictions with the backdrop of Governor Hogan's moratorium, but the CDC order that came out since then is quite a bit stronger. And I will say, I'm now watching as other states, New Hampshire, for example, is interpreting the CDC order to not even allow the starting of eviction cases. And to be honest, I don't know where the state's going to go on this, but I will say that with just a few months till the start of the legislative session, a presidential election, whole new debates about what stimulus and a Q3 revenue forecast is coming, it would really put the system, all of us, the legislators, our constituents, and the governor and the judicial branch on equal footing to take the most generous to our constituents interpretation possible of the CDC order, and for which we now have precedent from other states, and to make that our policy. That would buy us time till January's legislative session to get our house in order with all branches of government co-equal participants in what happens vis-a-vis evictions. So it's a question, kind of, but a request. So one, just to reiterate, was about enforcement of safety protocols for workers, including things like masks. And two is a possible revisiting of the evictions question in light of different states' interpretations of the CDC order. Thank you.
So let me start with your first question, and then I'll see if Judge Adams or Judge Shockley want to add on. And I believe that the chief has unmuted, so I will let her address the second question regarding evictions, because circuit court administrative judges can't really address that question. But in regards to the enforcement issue, if I would encourage members of the community, both lawyers and non-lawyers, to raise with administrative judges if they see other judges not compliant with the chief's order regarding masks and the like. I myself have had that raised to me. I've addressed it. And I know that other administrative judges have mentioned that they've addressed that. We don't need names of people making the complaints. We just need the information so that we can make sure that everybody is compliant in that regard. If folks are just walking around the courthouse and they have removed their face masks or are not following the rules, the sheriffs are empowered to act appropriately in that regard. And I know that all administrative judges across the state have been in communication with their sheriffs. Of course, first would be a gentle reminder that a face mask is required and that it needs to be worn properly. And if somebody's not compliant with that, they can be removed from the courthouse. Judge Adams, did you have anything to add?
That sums it up.
I'll weigh in if I may, Mr. Chair. What Judge Ripken said. I've been informed of several circumstances where a judge has opted, for whatever reason, not to wear a mask. The administrative order, as Judge Ripken mentioned, and I'm sure Judge Adams and Judge Shockley would echo this, it applies to every single one of us who enters the courthouse, and that judges are not excluded from that. Steps have been taken in various courthouses, and ultimately it could get more challenging, but yet we will do what is necessary to protect the safety and health of those who enter our courthouses. So whether the question concerns personnel or a judge, we are following through and we will continue to. I thank you, Delegate Moon, for that question. For the second question that you had, we have, no surprise, Mr. Chair, we have John Morrissey on standby, Chief Judge Morrissey, just on the off chance that someone like the inestimable Delegate Moon would raise a question about eviction. So with your permission, we can bring him on. I know he's listening. He better be.
Only because you called Delegate Moon inestimable. That's fine.
As you all are.
Oh, well, so very kind. Shocker. There is Delegate Moon. There he is, Delegate Moon.
Mr. Chair, I'm appearing, unfortunately, under the name of Susie Pellis, who's our assistant here at my headquarters. And I was called into this, and I had other people in my conference room, so I was dutifully wearing my mask, and I've taken that off now because there's no one else present. Good afternoon, everyone. For the record, my name is John Morrissey. I'm Chief Judge of the District Court. Delegate Moon, I have issued a communication with respect to how we intend to handle the CDC agency order. I would not define that as a moratorium. When I first heard that they had issued this, I said, great, a moratorium, that'll make it easy for me, right? Because then we wouldn't have to handle any of these cases, but that is not what the order actually says. And it is different from the CARES Act order that was, in my opinion, more of a moratorium. It still wasn't a moratorium, but it prohibited filing. The CDC order does not, in its body, prohibit filing. It prohibits evictions. Many of these issues that are going to come before the court are judge decisions. They're not something as a chief judge I can direct or instruct my judges to before they actually hear the arguments of the case, take a position on. It will be treated as an affirmative defense. There's basically three buckets that you can think of cases that may come before the court. Those that where a tenant gave the declaration, they're required to give a declaration to the landlord. Why the CDC decided that they would give it to the landlord rather than the court is beyond me. Had I drafted that, it wouldn't be that way. But nonetheless, they have to give the notice to the landlord. If they've done that prior to the filing of the suit, then the tenant can raise that as a defense before the court that the landlord should not have even filed the case, and that will be entertained by the court, just as the landlord's arguments to the contrary will be entertained, and a judicial decision will be made that can be appealed if appropriate by either party to the higher court. That would be the circuit court in this case. With respect to the second kind of bucket of cases, that's where the landlord has already filed, and then the tenant gives the landlord a declaration. And again, it would be beneficial for the tenant to bring that declaration into court, and the court will rule on whether that is adequate or not. And then the third would be where the court has already issued. Remember, there's two parts in a landlord tenant. There's the filing of the failure to pay rent action, which gives a judgment for possession. It does not give a judgment for eviction. And it's not eviction court, it's landlord tenant court that we're doing. So it would be give a judgment for possession. And then if the landlord gets a judgment for possession, they have to wait 4 business days before they can file an appeal. And then it would ultimately, the landlord then has to file a request for a warrant of restitution that would authorize the eviction. The court will review that warrant of restitution to determine the legal sufficiency of it. And if it agrees, then the court will sign that and turn it over to either the sheriffs or the constables for the actual eviction itself. If a tenant files that declaration after the warrant of restitution has been authorized by the court, while it's at the sheriff's office up to any minute before the actual eviction begins, that individual, or the landlord for that matter, could file a motion with the court testing the validity of the declaration at that point. And that's where we're at on these cases. I have looked at other states. To be very honest with you, it's a mixed bag all the way across the United States.
Can I, Mr. Chair, can I just
briefly, we're going to try and hold this to 13 more minutes that we can
very briefly. In your head, does the tenant have to show up throughout those steps to defend themselves from the process, or has it been steered in such a way that that's minimized?
Most of the landlord tenants across the state would be that the tenant has to show up. However, in every court across the state, they can request a virtual hearing, and that can be by telephone or by video conference. If they don't have the capability to do it by video, we understand that, and we would allow telephone on something like that. But they have to request that of the court, or they have to show up to assert their right.
Okay. Delegate Fisher asked, sent me a message, and I'll follow up on this. If it's possible to get a memo or something that lines out that process that you laid out, Judge Morrissey, I think the committee would appreciate it, because we get a lot of questions from constituents. And I think that the judiciary has already put out something along that line, but if it's possible to put something in writing, that would be helpful. I see questions from Delegate Bartlett and Delegate Williams, and then I have a couple more, and we'll just have to be as quick as we can. Delegates Bartlett first.
Thank you. Thank you, judges, chief judges, and everyone for being here today. And thank you, Delegate Moon, for your question, because those are some thoughts that I had as well. Chief Judge Morrissey, I have one more thing I wanted to add, and that was with respect to, you said you have looked at other states, and I appreciate that. It is, the CDC order obviously is subject to interpretation, and I can only imagine that this is not an easy task. However, I would urge you to consider following the lines of a state like Missouri, in which the declaration can stop the eviction process from even starting. So if the tenant has the declaration, then it would stop the eviction process from even going forward, which I think you might have been alluding to when you were saying why, that the declaration could have been set up where it goes directly to the court. Is that kind of what you were thinking when you said that?
Well, what I meant by that, Delegate, and that's a very good question, is that someone has to assert this. It's the way, in my opinion, that the CDC agency order was drafted, that it doesn't prohibit the filing. It prohibits an eviction. It says any action that would cause an eviction, but it's a two-step process in Maryland, in that a judge needs to hear that to make a decision as to whether that should have been filed in the first place or not. It's not a decision that I can make. I can't Each judge has an independent duty to look at the facts of each case as presented to them and make a determination based on those facts. And as chief judge of the court, of the district court, I can't tell a judge how to rule. I can't give an advisory opinion. I can't give legal advice. And that's the nature of what judges do. They have to make decisions like that on a day in and day out basis. And if either party disagrees with that decision, they have the right to appeal that decision. And again, because these are summary proceedings, the trigger for an appeal is very quick also. It's 4 business days. And then it'll go over to my colleagues who you've heard testify today on the circuit court, and then they'll have to deal with that appeal issue. And if they don't like the appellate decision at the circuit court level, they can appeal to the Court of Special Appeals, our intermediate appellate court. And then if they don't like the decision at the Court of Special Appeals, they can ask Chief Judge Barbera's court to review the decision.
Okay, and that was just one quick question I had, but I did have 2 other things I wanted to bring up. One, with respect to normal, whatever that is nowadays, life, when one could just walk into a courtroom because one was a law student and you wanted to see how courts work or whatever, and you could easily do that where permitted. What is there any type of mechanism for some? 2 questions. So when I look at the docket now, previously I would look at the docket the night before. I could see exactly all the cases that were going to be heard. Is there a link, or will there be a link associated with any of the trials, so that if I were a person looking at the docket, I could also look at the trial or later go back and look at the trial? And with that question, is there going to be a transcript? What is the method of obtaining a transcript now with this new system, the new virtual trials, jury trials that we have?
So I'm not sure I completely understand your first question, but in response to the second question, it is the same. Transcripts can be obtained the same. There is recording of each proceeding, whether it's remote by telephone, remote by video, a Zoom meeting, or a Zoom proceeding. All of that is recorded, and transcripts can be ordered and obtained in the same manner they were before. I'm not sure exactly what you're referring to in terms of a link.
Yeah, sure. What I was referring to is, would an individual of the public be allowed to view a case, a trial, live?
Well, there's still a law that prohibits live broadcasting of a proceeding. I can see that Judge Adams would like to say something, so I
was going to say, if for criminal trials, they will be in the courtroom, so they can still come in. There may be limited space, so they can still come in. For civil trials that are, right now we have Zoom virtual trials. You can't view it, but you can get a link to listen.
Okay, so what you're saying is, during the proceeding, you can have a link even though you can't view it. Is that what you were saying, Judge?
Yes.
Okay, Thank you very much. That's exactly what I wanted to know.
Delegate Williams.
Yes. So my question, I know, thank you, Mr. Chair, and thank you, the judges, for being here this afternoon. I know Delegate Moon asked a question about landlord-tenant. I wanted to kind of also expand that to the foreclosures as well. I noticed that the foreclosures had stopped, obviously, at the beginning of the pandemic for obvious reasons, but that they are resuming. And so in those instances where the foreclosure sales are now resuming, if the individuals are not vacating, typically what will happen is a motion for possession is filed. And so given the CDC, I don't want to call it a moratorium, I guess order or guidance, how would that play out as well in a foreclosure proceeding, as well as with regards to a writ of execution if you're levying a civil judgment, either circuit court or district court?
Either Judge Adams or Judge Shockley, you want to jump in?
Well, as it relates to the foreclosures, you're correct that some foreclosures are proceeding, but most of the foreclosures that we see are still subject to stay if they're federally insured, Fannie Mae, Freddie Mac, FHA, anything along those lines. So if the mortgage or the lien instrument is not of that type, the lender can file an affidavit or declaration saying that they may proceed. But honestly, most of the foreclosure cases that we see are still stayed. Commercial foreclosures are going forward because they're not subject to that restriction. But most of the residential that we see are still stayed and are not moving forward. And I don't know whether the other judges see the same thing, but that's what I'm seeing here.
That is our experience in Anne Arundel County as well. We are watching carefully for those declarations, and if a case comes in with a residential foreclosure with the declaration attached, then it is being processed, but the declaration is required.
That is the same in Prince George's.
All right, let me ask a couple more questions and then we're going to try and move along. One of the questions that I've gotten from practitioners, not picking on Judge Ripken, not only in Anne Arundel, but in other jurisdictions, is it feels like, and perhaps this is only anecdotal, but it's not entirely clear. For example, I heard from one practitioner in Baltimore City who said that they are going to do 4 jury trials in the month of November, and that's it. And they're going to effectively sort of prime the pump there and then maybe ramp up in the next month, maybe not. I had another practitioner tell me that in Howard County, they aren't planning to start jury trials until January. Is there, while I mean, I've seen the different phases that we've gone through, but I'm wondering whether there is a different level of opening, I guess, depending on what jurisdiction you're in. And first, is that true? And second, if it's true, is there a concern that having those different standards across the state can lend itself to some real inequities across the state? And then I'll ask a couple more.
I think that's a really good question. So jurisdiction by jurisdiction, as both Judge Adams and Judge Shockley can attest to, we are watching the numbers, what's going on in our jurisdictions. And so, for example, the rates of positivity may be higher and I believe they have been higher in Judge Adams' jurisdiction. So she can really speak to that. Whereas Judge Chanley in Calvert County would tell you that the rates of positivity are much lower. So we are all following not only the CDC and the Maryland Health Department, but in constant communication with our local health department as to what is appropriate jurisdiction to jurisdiction. And then you have in the issue that Judge Shockley mentioned, the size of the court, what the court can handle, the number of courtrooms, the spaces in which jury selection can take place. And that has to be factored in. I am not aware of anything that has come out of Howard County. And I had the Judge Tucker on the call yesterday, and he did not say that jury trials were not resuming in Howard County until January. So I suspect that may be a rumor. But each jurisdiction additionally is prioritizing cases in terms of what they can do, what is appropriate in their jurisdiction, and everybody's getting them set up. But you're right, it may vary jurisdiction to jurisdiction. I think we are all, to a one, focusing first on incarcerated defendants in criminal cases because we understand we have to get those done first and foremost, and civil takes a certain priority over criminal. That said, there are some criminal cases, there are some civil cases that we can do quickly because they only require 6 jurors. So depending on the number of left in your panel, say you picked a criminal case and you have a smaller number left and a civil jury in the queue, then you can go ahead with that civil jury. So it is, as it always is, even in a non-pandemic time, an issue associated with prioritizing and an issue that must be addressed jurisdiction by jurisdiction. Judge Adams?
I'm happy to hear what you said about Howard County and I think the person is watching here today just to find out what was going on. That seems to be one of the common threads, though, as I've heard from people, is nobody's really sure what's going on across the state. And I will even go so far as to say I think there's sort of a feeling of, are they really going to do this? Are they really going to open? Because I think and then this goes to another question. It goes to a couple more questions. That there is that discomfort out there, and particularly from some of my constituents now in Baltimore City, with the conditions, the existing conditions at Circuit Court, which were already challenging for jurors in those rooms to begin with. Now, with a ventilation system that is not great on a good day, it lends itself to questions of, can we be confident that the ventilation system is up to scratch, that we are going to be able to get adequate airflow in and out of some of our older courthouses? And that is a big concern that I've heard from people, and it goes to a reticence about showing up for jury duty.
Which I think goes, I'm gonna let Judge Adams talk.
No, I would just say that's why the report and the committee painstakingly went through every aspect of a jury trial and how it impacted each individual court across the state, because they are so different. Coupling that with the fear that people have with this pandemic. And the priority of that report is just keeping people safe. Now, you're absolutely correct that jury service is not going to look like it used to. For example, on a regular day in Prince George's County pre-pandemic, we were bringing in 400 people on Mondays and Tuesdays for jury trials, impaneling 5 to 7 jurors a day. That's not going to happen because we can't bring that volume and be safe. So yes, jury trials are starting, but it's not going to be like it was. We're not packing people in. Yes, like you heard in Baltimore City, they may do 1 a week. We're only going to be doing 2 to 3 criminal trials a week because that's all we can do safely right now. Now, as we go through this and we get confident with the process and citizens get confident coming in and seeing that we're doing everything we can to keep them safe, we may be able to do more, but we're going to err on the side of keeping people safe. And like I said, that's why we're looking at other venues so we can do that to keep people safe. But we're not going to just open up and pack people in.
Are courthouses doing what they need to do to improve ventilation and to provide some of those safeguards in the ventilation systems in the courthouses to give people some level of comfort? Yes,
I can speak to Prince George's County. We've worked hand in hand with our Office of Central Services, had them walk through every inch of this building, look at the courtrooms, look at the ventilation systems to see how the airflow goes, and just to make sure we have this building as safe as possible. And I know my other colleagues around the state too have worked hand in hand, and that's the beauty of work hand in hand with our local jurisdictions to make sure that our courthouses are as safe as possible.
Mr. Chair, may I just have 20 seconds? If Ms. Harris, Pam Harris, can speak to the ventilation issue among the circuit courts more broadly. I believe she may very well be on this call listening.
Yes, good afternoon to everyone. The conference, the administrative judges have had numerous conversations about dealing with their local building superintendents to make sure that our ventilation systems are up to par. John Morrissey, Chief Judge Morrissey, has also worked with DJS, as we have for the state buildings, that we had some concerns, including the Court of Appeals, which is a building that is in dire straits. But we have been working with DJS to get HVAC systems there and ventilation systems there worked on immediately. So yes, we are aware of the ventilation and we are working with local and state officials.
Are there further questions? I have a further question about questions related to pretrial release. It's 2:05. I don't want to go too much further, but I'll just say this, and it's a request for more information more than anything. As we go forward, one of the issues pre-trial that we're having is people are in fact being put on pre-trial release, and rightly, so that they avoid sending them into local detention centers, and that completely makes sense. One of the questions that I have gotten, and I got from another constituent, had to do with who is supervising people who are on pretrial release effectively if they're not going through an existing program, an existing pretrial program. I mean, my understanding is that some people are using private providers to be released pre-trial, and I've got questions and concerns as to who is actually doing the supervision of some of those places or those companies. Who's doing supervision of the companies who are supposed to be doing supervision of the people who are out on pretrial release? It strikes me that if we're going to have to do a lot more in the way of pretrial release, and we're making people pay to use GPS monitors and other equipment, that first we should make sure that private companies, if that's who they're using, are actually doing their job with the monitoring. And I guess it, for me, there's a further question of, why isn't all of that being kept in-house in the first place? I know it's a big issue to drop in at the very end, but I had it on my list, and I wanted to focus more on the jury trials today, but this is an issue that's important to me as again, it is a cost for defendants, to be sure. There's a victim safety argument here. There's all kinds of different sides of it. And if we're going to be doing more of it in the future, I'd like to know more about how we oversee those private providers, and whether there are ways that we can alleviate some costs on people who are being released that way. So I'm going to let you off the hook for that, but I'd ask for something from the judiciary on that issue. With that, I don't see any further questions. I just got one more question, so I'm going to go ahead and ask it. Sorry, we can't let you off the hook entirely. I know, speaking from my own experience in Anne Arundel County, my understanding is the state's attorney's office and the Office of the Public Defender were involved in the reopening discussions inside the courthouse. Is that correct, Judge Ripken? And if that's correct, is that the case across the state? She's muted.
You're muted, Judge Ripken.
We're getting there.
Sorry. It is the case in Anne Arundel County, and we've met with the state's attorney, the public defender, as well as private counsel throughout this process. And in fact, we have another meeting on Thursday. And as a result of my very regular calls with every administrative judge in the state, I am confident in saying that that is the same across the state. Do you agree, Judge Adams and Judge Shockley?
Yeah, absolutely.
Same here in Worcester.
Yes.
Okay. All right, with that, I have to stop us. We do have the Attorney General on, who's been very patient. And we do thank you all very, very much for being part of this, this hearing today. Thank you all very much for your time.
Thank you.
Thank you.
With that, now the Attorney General is with us. I do want to recognize the new junior delegate from Harford and Baltimore County, Delegate Eric Hand's son, who is there, who is joining us today and is fast asleep. Oh, maybe not so asleep. But I did want to recognize them before we begin. But I'll go now to the Attorney General, Brian Frosch, who will talk about the Access to Justice work group that he has organized. Attorney General, if we can get him unmuted, maybe. We'll see.
Yes.
There we go.
Thank you very much, Mr. Chairman. And members, it's a pleasure to see you, be with you, even if virtually. And I want to give a shout out to Chief Judge Barbera and her crowd. They're really doing an outstanding job, as we know, in very, very challenging circumstances. Mr. Chairman, would you mind if I just addressed your question about the monitoring of people who are released.
Not at all.
It seems to me that the responsibility for paying for the devices that are required to monitor these folks ought to fall in the laps of the local governments. It should not fall on the people who are being released. First of all, there are folks who can't afford it, and the folks are often unable to work while they're on release. But more importantly, the local governments are saving money for every person who's out of jail. The average costs of holding somebody in jail are now, I think, well over $100 per night. And the cost of the devices ranges from $10 to $30 a day. So local governments are making money when these folks aren't being housed in jail. It seems to me from every perspective, the rule ought to be that the local government foots the cost just as it would if the person were held before trial in jail. Sorry.
No, that's fine, Mr. Attorney. I don't know that I disagree. And to be clear, there's been legislation in this committee on that issue. And I will admit to having some questions or concerns about it. I think we're going to look at it again, particularly in light of what's going on right now because of the costs that is out there. But I also think there's a question of the quality of supervision, and that's something that we should be getting what we're paying for, or that needs to be addressed too. And so with that, I will shut up and send it back.
Okay, I apologize for the diversion. Well, I really appreciate the opportunity to talk to you about our Access to Justice Task Force. I mean, everybody knows at this point that the COVID-19 pandemic will hit low-income people, Black and brown people, harder than the rest of society. And it has exposed and exacerbated challenges in obtaining access to justice on a scale, a magnitude that we really haven't seen before. And the economic upheaval that business closures and illness has created significant hardships that really the civil justice system can resolve. And I'm talking about missed rent payments that lead to evictions, eviction notices, disputes over medical or consumer debt, or people who are wrongfully denied public benefits necessary to keep their family afloat, or not even denied, just don't have access because the system isn't functioning as it should. Lots of folks will be left to navigate on their own the complicated post-COVID civil justice landscape. And yet, unlike in criminal cases, the folks who are going to be dealing with this don't have a right to an attorney unless they can pay for it. So in order to address this and other aspects of the pandemic, we stood up the AG's COVID-19 Access to Justice Task Force this spring. We did it in partnership with the Maryland Bar Association and its Access to Justice Commission. And what we did was we brought together very talented folks. And I say that not just because I'm including you, Mr. Chairman, and Delegate Bartlett, Delegate Quarterman. We have 3 senators as well. But we have a talented and diverse group. It includes, one of the vice chairs is Judge Andre Davis, retired from the U.S. Court of Appeals of the 4th Circuit. We have retired former Chief Judge of the Maryland Court of Appeals, Robert Bell. We have former Attorney General Steve Sachs. We have 3 judges, 2 of whom were appointed by our Chief Judge Barbera, Judge Cox from the Circuit Court, Judge Mayer from the District Court, and as it happens, Judge Skirty is the president of the Maryland Bar Association, so he's serving in dual capacities. But and of course, you know, we have people who represent business, people who represent the healthcare sector, government, housing, advocates, and I've been really impressed at how talented and determined this group has been to address the COVID-19 challenges that we're looking at. The goal of the task force is to ensure that when Marylanders encounter the civil legal system, justice is accessible, that it's fair, that it's equitable. And equitable access to the justice system will protect public health. It will spur economic recovery. It will help growth reduce further harms for those who are most vulnerable. The task force is going to focus its efforts on both short-term and long-term civil legal issues that are created by or exacerbated by the COVID-19 pandemic. And those areas include housing, consumer fraud, debt, public benefits. It will also address the looming deficit in funding for civil legal aid and the disparities in outcomes for people of color, Black and brown populations. The task force will develop strategies. It'll devise solutions, drive reforms, and innovations, we hope, that are necessary to achieve justice for all Marylanders. The suspension of evictions for failure to pay rent and the suspension of consumer debt cases expired on August 31st. There are about 330,000 renters who are predicted to face eviction by the end of 2020. And let me say, we wrote to Governor Hogan, and I'll come back to this in a moment, and we asked him to extend the moratorium on evictions. It's not been done so far, but I think, as Delegate Moon said, it's something that the state should be doing, and certainly the General Assembly isn't going to get to it in time to make a difference before the end of the year, but it may be on your radar as when we come back in January. So let me give you some of the objectives of the task force. We want to keep Marylanders housed. Even before COVID-19, we had an outsized number of eviction filings and judgments each year. To prevent mass displacement, we need to identify and connect families to rental assistance programs, to provide ways for parties to resolve problems outside the courts and expand resources that are available to tenants within the courts. We need to keep Marylanders fed. Hunger is a problem in our state. The Maryland Food Bank saw an 82% increase in the amount of food delivered in April of this year compared to April of 2019, 82%. From their estimates, almost 1 million Marylanders may find themselves food insecure, and that's, you know, a euphemism for hungry because of COVID-19. Attorneys from legal services organizations report that many Marylanders face barriers in receiving their benefits or are being wrongfully denied. To ensure that Marylanders are able to feed their families, we need to identify the barriers to accessing unemployment, public benefits, opportunities to expand access to critical services. We also want to keep Marylanders safe. More than 2,600 Marylanders have died from COVID-19 virus. Thousands more have tested positive, you know, been hospitalized. The hardest hit have been essential workers. those in healthcare, food, transportation, delivery workers, and these are disproportionately Black and brown people. They lack adequate personal protective equipment, testing, other recommended safeguards. The stress and anxiety that's caused by job loss, forced social distancing, have compounded these outcomes. Many healthcare practitioners and victim advocates predict an increase in domestic violence, in child abuse, in elder abuse, and neglect. Another objective is to keep Marylanders secured. The pandemic has devastated our economy and it's caused record unemployment rates, nearly 15% nationwide, 10% in Maryland, concentrated among low-wage workers. The state's reported receiving more than 600,000 claims for unemployment insurance since the pandemic began, and it's probably higher because of the backlogs that we've seen, the delays, and they suggest that 600 is probably lower than what we're really experiencing. Beyond the resulting food and housing insecurity, many families will also face mounting medical and consumer debts and debt collection lawsuits. We need to keep Marylanders connected. You know, too many in our state don't have access to technology, to the internet, and yet our courts will be moving to conducting remote hearings and online dispute resolution. We have to make sure that we get entire swaths of our, or to prevent entire swaths of our population from being shut out of this process just because they don't have access to technology, to the internet. It's also critical that our work be done in collaboration with representatives of all impacted communities. And the information has to come out in ways that are clear, that can be read by lay people and understood by lay people, that it's accurate, but in plain language. So the task force has had several meetings, and our committees, and I forgot to mention before that we have a number of committees of the task force. There are probably 40 members of the task force. There are probably 300 people who are on the committees that are looking at this. And the task force looked at the work, the preliminary work of these committees. And I think on September 1st, we sent a letter to the governor, and we requested that a portion of the money that Maryland has received from the Federal CARES Act be devoted to keeping people in their homes. And we know that Maryland's received $2.4 billion. As far as we can tell, we know that the government has spent $400 million of that $2.4 billion. We don't know whether the rest has been spent. I'm pretty sure that all of it hasn't been spent. So we asked that, in our letter to the governor, we asked that $143.5 million in CARES Act money be devoted to the following: $135 million to rental assistance. And this is money that would allow residents to remain housed while landlords would also get paid and be able to hold on to their properties and meet their mortgages and other financial obligations. We asked that $5 million be devoted to civil legal aid funding. The civil legal aid has taken a huge hit in Maryland. Its funding sources have essentially dried up. The filings in court have dropped precipitously. There is essentially zero interest being paid on lawyers' trust accounts, and they're hurting very badly. Just to keep up the level of services that they've provided in past years, at least $5 million is going to be necessary. We asked that $2.8 million be used for case management, for counseling, for social services supports. And this money would contribute to reinforcing the case management, counseling, social support services that are typically used to manage or resolve civil legal matters. We asked that $800,000 be used for public awareness. Folks don't know where to turn when they're served with a summons for eviction. They don't know where to turn when they've received a lawsuit, a summons from a debt collection agency. Public awareness campaigns, we believe, could be done effectively, efficiently, and would dramatically improve the access to justice. I'm getting toward the end here. I'm not going to speak for 45 minutes, but a couple more points. We also wrote to Governor Hogan, and we pointed out that we got a settlement from Deutsche Bank a couple of years ago. It was for $20 million, and we've distributed the money that was owed to municipalities, to counties, to the state retirement systems that that were hurt by Deutsche Bank's activities in the residential-backed mortgage securities. It's RMBS, residential mortgage-backed securities. They overstated the value of the products that they were selling to many of the governments. We've got money left over after distributing to our municipalities and counties. It's technically, I think, in our control until you say it isn't. And we suggest that Governor Hogan take $8 million that remains and use it for rental assistance. We think that would be money extremely well spent. So let me just say before I turn to your questions that the funding that we're talking about here does in no way cover the full range of needs that we expect to see for Maryland residents as a result of COVID-19. But the task force members are confident that the needs identified in these letters require urgent investment. And that investment can not only help people save their homes, but it can also help us on the road to Maryland's economic recovery. So thank you very much, Mr. Chairman. I'd be delighted to answer questions if there are any.
We have a question from Delegate McComas. Delegate McComas, go ahead. If other members of the committee have questions, please indicate in the chat and I will find you. Delegate McComas.
I think she may be muted.
You have to unmute.
Okay, I think we're good. All right. Thank you, Mr. Chair, and thank you, Attorney General. I find it kind of interesting that you're dealing with economic issues for the families, and yet I think that with the virus, a lot of the domestic, which would be, you know, child custody and visitation, has also been very compromised. And I know this is not really the question I was going to ask, but I want to divert a little bit. For several years, we've tried to codify the case law for custody, and we can never seem to get it anywhere out. And I'm not disparaging my current chairman but we've tried a number of years, Delegate DeMay and myself, and it seems that if it was codified, it would make it a lot easier for people to understand the factors for custody. But that's just kind of an aside, because I notice you're not dealing with any of those kind of domestic things, which the virus is going to affect. But the question I wanted to ask was, and you sort of answered it, about the $135 million, if it could be used for rental assistance. But let's assume maybe it isn't. what solution can we have? Because a lot of the folks that are renting properties, they don't own them. They have mortgages, and those mortgages have to be paid. So it's kind of like the snowball runs down the hill and catches everybody. And I mean, I don't think it's a good public policy idea that we have all these people homeless and evicted and on the streets, you know, living in tents. That's not good. But what can we do to kind of stabilize that rental market so that the landlords are not foreclosed upon, and that the renters can stay in the property, and that it's kind of creates a win-win and a stabilization of the housing situation, if assuming you wouldn't get that 135 million. And that may be just a drop in the bucket. I don't know if we know how many people rent versus how many own and all that configuration.
Well, it's a great question, Delegate Nokomis. And first of all, the 135 million we expect would get us to the end of the year, and maybe even short of that goal. But you know, we're thinking that would last until the end of December. And it does a couple of things that I think are very, very helpful. I mean, first, the tenants get to stay in their homes. Second, the landlords get money. They get the rent. So they can pay their mortgages. They can keep their properties running. I mean, we understand completely how important it is for the landlords not to lose their businesses. It's not going to help anybody if these residential buildings are foreclosed upon and either run by a bank. It's not usually a very happy outcome for anybody, or sold to somebody else who may not be as effective a manager as the landlord that has been replaced. But the point is that if we devote this money to residential assistance, it'll help both the tenants and the landlord. And thirdly, it'll have a positive impact on our economy. So, you know, it's a trickle up situation in effect. And it should benefit a lot of people.
Okay. Are there further questions for the Attorney General? My goodness, you've left judiciary questionless, except for Delegate McComas, and that's only one. I don't know what to do. All right. If there are no further questions, I do really appreciate you taking the time to speak with us, Attorney General. I think that the work of this group is very, very important. I'm very happy to be part of it, and I thought it was very important for the committee as a whole to hear everything that you're doing and that the task force is doing. So I really appreciate your time.
I really appreciate the opportunity, Mr. Chairman. Look forward to seeing you guys soon.
Absolutely. All right. Well, thank you very much. And seeing no further questions, I'll call this meeting to a conclusion and thank members of the committee and the judges and the Attorney General again. Thank you all very much. Have a very good day.